And it is 11 o'clock Pacific Standard Time and 12 p.m. Central Time and 1 p.m. Eastern Time. We're going to get started. Good morning or good afternoon, everyone, and welcome to this webinar, Independent Contractor versus Employee, the U.S. Labor Department and Your Career, with guest presenter Bruce Adelson. I am Rosanna Balistreri, and it is my pleasure to host today's webinar on behalf of the National Council on Interpreting in Healthcare. This webinar is a free webinar to everyone as an educational campaign and an effort to inform everyone, and everyone who attends, we hope that you can inform other people on the information that our guest presenter will be sharing today. And before I go ahead and provide a little bit more information about our presenter, I have a few brief housekeeping comments to share. This session is being recorded, and the recording and presentation slide deck will be posted on the NCIHC website. Everyone joining us today will also receive a link to the recording in an email next week. As a reminder, certificates of attendance will not be issued for this webinar, and this webinar has now been approved for continuing education for interpreters. Please use the Q&A box to submit any questions or comments for the presenter. An example of the Q&A icon is displayed on this slide. And I will share your questions and comments with the presenter during the Q&A period at the end. But please do send your questions and comments throughout the presentation. Please note that if you send any messages in the chat box, they will be visible by all attendees unless you select to send only to the hosts. But again, please use the Q&A box to send questions or comments that you'd like the presenter to address during the Q&A segment at the end. And now, it is a great pleasure to introduce our guest presenter for this topic, Bruce Adelson. He is the CEO of Federal Compliance Consulting, and he's a former U.S. Department of Justice senior trial attorney. During Bruce's federal career, he was responsible for enforcing Title VI of the Civil Rights Act of 1964, which requires federally funded organizations and governments to provide language access for limited English proficient people. Now in private practice, Bruce has assisted and consulted with multiple local and state governments, healthcare organizations, not-for-profits, courts, and law enforcement agencies concerning language and disability access. He has litigated and been an expert witness in many federal and state lawsuits concerning national origin discrimination, language access, disability discrimination, and voting rights. He is a faculty member at Georgetown University School of Medicine and University of Pittsburgh School of Law, where he teaches implicit bias, civil rights, cultural awareness, and organizational culture. He has also taught at Harvard, Cornell, and Auburn universities, the Johns Hopkins University School of Public Health, and University of Baltimore School of Law. He is the Americans with Disabilities of Act consultant to the Idaho Supreme Court and the New Mexico Administrative Office of the Courts. And now it is my pleasure to turn the presentation over to you, Bruce.
Thank you so much, Rosanna, and good morning, good afternoon to everybody. I hope everyone is having a good Saturday, good kickoff to the weekend. So we're going to be talking about independent contractors and employees, the U.S. Labor Department and your career. So we're going to discuss the legalities of the difference between the two, what's happening in Washington, what's likely to happen in Washington, some trends nationally, and just to kind of raise this issue up the list of priority items as it may affect you, your careers, and your current ability to do the great work that you're doing. So as Rosanna said, there will be opportunities for questions. At the end, I'm going to move through my slides, and I'm going to pause at various points so you have an opportunity to read the material and for me to discuss a little more in depth. Not surprisingly, this is a pretty complex issue, but it is a big issue that is facing a lot of people around the country. Certainly the kickoff was a couple of years ago in California, and this whole issue of worker classification has just spread, and it's becoming a bigger deal and is now one of the priorities of the Biden administration. So with that, so let's start. So as a lawyer, one of my favorite things to do is give disclaimers. So my disclaimer today is the material that I'm discussing is property of myself and my company. All intellectual property rights are retained by us. Today's material is educational and informational only. No legal advice is being provided. We're just having a nice talk about this complex area of law and policy. So to get started, let's talk a little bit about, who is classified as what. And I'm going to use some information from the Internal Revenue Service, which I think is written pretty well and gives you a good idea of this whole classification distinction. So people like doctors, dentists, vets, lawyers, accountants, contractors, subcontractors, public stenographers, auctioneers are in what's called an independent trade, business, or profession, in which they offer their services to the general public. They are generally considered independent contractors. And I typically, in the work that I do as a lawyer, as a consultant, I'm an independent contractor. I'm not an employee of any organization other than my firm. However, the people that I just referenced, or the professions that I just referenced, whether or not someone is an independent contractor or an employee, and this is really important, you'll see this play out as we go forward. It depends on the facts of each case and each situation. So one of the things that's important to remember, if you sign a contract that says you're an independent contractor, it doesn't mean you are legally. Whether or not you are legally depends on the circumstances under which you work with the entity that is hired. And we'll talk a little bit about more about that later. But the second paragraph has one of the keys. The general rule is that someone is an independent contractor if the payer, if the organization, the company for which you're working, has the right to control or direct only the result of the work and not what will be done and how it will be done. So the short description of that is, if you're working for a language services company, a hospital, no matter who it is, and they have the right to control exactly how you do your job, when you do your job, where you do your job, or direct you to take certain types of training, for example, that typically may indicate that they have the right to control or direct you. That's typically something that applies or is done with an employee. But an independent contractor, by definition, is independent, meaning that how you do your job is essentially up to you, and that you don't have an office at the language services provider or the healthcare provider. Your office is typically at home or some other place that is independent of the organization that has retained you. So remember that right to control, because that's a very key phrase in legally determining whether you're an independent contractor or an employee. And as you see at the bottom, the earnings of someone who is working as an independent contractor are subject to a self-employment tax. It's a federal tax that you are paying the share, for example, Social Security. You're paying your Social Security tax and the share that your employer would have paid if you were an employee. So I think this is really good. If you are, and this is also according to the IRS, you are not an independent contractor. If you perform services, it can be controlled by an employer. What will be done and how it will be done. This applies even if you are given freedom of action. What matters is that the employer has the legal right to control exactly what you're doing. So I know that that's a little bit repetitive from what I said in the first slide, but I really want to drive that point home so you can look at how you do your work for various organizations to kind of get a feel for Well, do they control what I do in the sense that we've been talking about? That could mean that you're not an independent contractor by law. Instead, you are an employee. And as you see at the bottom again, if the employer-employee relationship exists, regardless of what it's called, remember, whether or not you sign a contract that says you're an independent contractor typically doesn't matter. It doesn't matter how you refer to the relationship or the organization that retains you refers to it. There are all kinds of factual clues, cues, and indicators that determine by law, are you an employee or a contractor? So that's really important to remember. And I'm going to pause here so you can read the screen a little bit. So this whole area, this independent contractor versus employee, it all is basically referred to as worker classification or misclassification. Worker misclassification involves classifying workers as 1099 independent contractors when they should be classified as W-2 employees. As you know, if you're an independent contractor, you get a 1099 tax form. If you're an employee, you get a W-2 that's a summary of your wages, benefits, and taxes. Businesses are required by law to ensure their workers, both W-2 employees and 1099 independent contractors, are properly classified. And there's the rub in a way. You'll see today what it can mean to an organization, not to the worker, what it can mean from a liability perspective to the organization if that organization misclassifies an employee as an independent contractor. When workers are improperly classified, they are deprived of various rights and protections, including minimum wage, overtime compensation, unemployment insurance, healthcare, pension, and workers' compensation insurance. So these are all rights that employees have under federal law and state law as well. So that's also a distinction. If you decide to work as an independent contractor, if you're legitimately an independent contractor, these protections are not something you're legally entitled to. They're only available to employees. Misclassification, according to the IRS, undermines federal and state revenue collections and creates an unfair playing field for employers who improperly classify their workers. Why? Because employers pay less overall to contractors than employees. They don't, what you see here, they're not required to pay unemployment insurance. They're not required, if they fall under certain thresholds, to pay for health care. There's no pension issue, workers' comp insurance. So there's a big difference in what the employer, the organization, the hiring entity pays out to a contractor than it does an employee. Depending on the severity of the infractions, meaning the extent of the misclassification, fines for worker misclassification are levied by the IRS, Department of Labor, and state agencies, and they can total millions of dollars. You'll see a couple of examples today. IRS penalties for misclassifying workers as 1099 independent contractors can range from, look at that, 22 to 43% of all of the contractor's earnings retroactive to the initial engagement. So let's say I was retained as an independent contractor 10 years ago, and I've been working for this organization as an independent. If it's determined that I was misclassified and it should be an employee, then the organization is liable for paying in that range, typically, as a penalty, 10 years of earnings to me. And there's also, of course, a government penalty and sanction too. So it's a big deal financially for the organizations. And that's part of the reason that this issue is getting a lot of attention. This is not an area where there's no bite, no sanction, no enforcement. Enforcement has picked up a lot over the last few years. And as you can see, there's a significant penalty for misclassification. And here's an example. This was a lawsuit. It's referenced at the bottom of the page. Fernandez versus Kinray Incorporated The number at the bottom of the screen is the case number. So if you Google the name of this case plus the case number, if you're interested in reading it, it should pop up for you. And if for some reason you can't find it, then you can email me, and I'm happy to send you the court decision or any other information that I can find. So this was a $7.5 million settlement in a lawsuit involving 115 pharmaceutical delivery drivers who claimed they were misclassified as independents and did not receive proper overtime pay. This was a suit in federal court in the U.S. District Court for the Eastern District of New York. So as you can see, it's a lot of money. So Kinray may have thought that they were saving money at the time. They didn't save any money. They wound up probably paying way more than they would have paid if they just classified the workers correctly according as the law states. This is a great chart that kind of gives you an overview of who's an independent contractor and an employee in the language services profession. So as you can see, on the left-hand side to my left of the screen, 75% of the people who answered this survey are self-employed, meaning they're contractors. That's a big chunk of people. Only 7% of language services professionals work in-house at language services providers. Only 6% work in-house on the client side. So this is a profession that, by this data, indicates that the vast majority of interpreters and translators are independents. They don't work in-house for anybody other than themselves. So this is an article in Slater a couple of years ago that gives you more of a feel for the numbers here. So a U.S. government determination, a Labor Department determination about misclassification of workers, or making a determination that the many people who are working as independents are really employees and need to be classified that way. So a government ruling about this could potentially bring about the reclassification of anywhere from about 67,000 workers to over 330,000 workers, independent contractors, costing employers up to potentially $6 billion a year in California alone. So you can imagine what the cost of this would be to the employers, to the organization, if the Labor Department decides to change the misclassification rules and make it likelier that a worker is an employee and not an independent contractor. So this is based on some white paper that was cited by the Joint National Committee for Languages after more than 50 language industry representatives met on Capitol Hill. But it's really a sobering number if you are an employer or an organization that works with interpreters and translators. That's a lot of money. We're talking about tens of billions of dollars nationwide, if not more than that. That's a huge hit for misclassifying workers. So what are the facts here? What are in addition to the right to control, independent contractor versus employee? So let's talk a little bit about that. Under the Federal Fair Labor Standards Act, an employer is required to pay its employees at least the federal minimum wage, provide overtime pay in any work week where an employee works more than 40 hours, and keep and preserve records about that. So again, I think it's useful for you just to compare what it is you do, how you work, the amount of time that you put in, how much time organizations tell you need to work, and just kind of do a thumbnail estimate of, well, wow, then, they seem to control what I do or they don't control, and think about this overtime, that if you are consistently working overtime and there's a right to control by the organization for which you work, that raises a big question about whether you're really an employee and should be entitled to overtime pay. It all started with what I'm sure many of you know is the California Assembly Bill AB 5, which became law 2 years ago in September 2019. As the law was originally passed, It bars virtually all Californians from working in the so-called gig economy. The law, which implemented a California Supreme Court decision, imposed a three-pronged test that identifies who still can work as a contract worker, as an independent contractor, and who has to be hired as an employee. So everything kind of cascaded in a way after that. After this, the bill was passed 2 years ago. There was litigation in California. There was a revision to the bill, which we'll talk about. So it all kind of started with this law. The bill, as you may know, exempts several professions from the test. Doctors, insurance agents, lawyers, hairdressers, engineers, for example, but translators and interpreters were not included initially, which was a big hit and a big cause of concern about why interpreters and translators were not included. Remember, the Fair Labor Standards Act applies only to employees, not contractors. So it's a minimum wage overtime pay thing as far as the benefits workers can get, and the requirement for employers obviously is paying the money and also keeping the records that the law requires. Since 2019, and even before that, there are a growing number of challenges by independent contractors claiming a right to collect minimum wage and overtime pay on the basis that they were really employees, not contractors, that there was a right to control, there was direction on the part of the organization that hired them that was much more than the law typically allows for organizations to supervise or maintain some level of direction over independent contractors. So as you may know, that California voters passed a very controversial and costly ballot measure that changed AB5 to exempt firms like Uber and Lyft from having to classify their gig workers in the state as employees rather than independent contractors. Not surprisingly, this successful effort cost a lot of money, more than $200 million in lobbying from Uber, Lyft, and the other organizations here. And that was known as Proposition 22, which went down in history as the costliest ballot measure in California history. So just like with a lot of things, it can be about the money and how things are addressed, who is involved in pushing certain agendas forward. So these companies got a big, no pun intended, lift from their lobbying efforts. But interestingly, although I haven't read the court opinion, yesterday, I think, a California state court decided that it's unconstitutional to classify Uber employees, I believe, as contractors. And the case, I think, was based on California state law, the California Constitution. So it really doesn't have a lot of, if any, impact in other places. But it is an interesting development. And arguably, if other states have laws that are similar to California's, that could prompt additional challenges in other states along the same lines as what the trial court decided yesterday. So I'm going to pause so you can read this a little bit. So you can see earlier this year, there was yet another challenge to the whole independent contractor employee thing in California. So ride-hailing drivers, as you can see, and the Service Employees International Union sued the state of California at the beginning of the year, asking the California Supreme Court to invalidate the proposition I just mentioned, Proposition 22, on the grounds that it is unconstitutional. Proposition 22 sought to avoid classifying gig workers as employees as required by California law, passed with 58% of the state's voters. So that's the court decision I mentioned yesterday. And I don't remember which California county court made the decision. But again, that's based on California law. The only way it would have any real application or meaning in other parts of the country is if other states' laws and constitutions were substantially similar to California. This is a interesting case from the U.S. Court of Appeals for the Third Circuit, which is based in Pennsylvania. And this gives you another kind of indicator about what tests are used to determine, okay, well, who's an independent contractor and who's an employee? So in that case, the court used a 6-factor test to make this distinction. I'll pause so you can read the 6 factors, but please pay attention to that first one. Right to control. Right to control is a big one. The extent to which your work is controlled by an organization is just legally dispositive. That's really the most important factor oftentimes in deciding, well, who's an independent and who's a contractor. So I'll pause for a few seconds so you can read. As you can see, one of the focuses of the 6-factor test is what you've done to invest in yourself and in your business. So if the organization that pays you has given you equipment, has required you to have certain equipment, has reimbursed you for the cost of that equipment, that probably means you're not an independent contractor because they are controlling what you can and cannot use to do your job. So that's an important measure of this misclassification. As you can see in the middle, one of the factors is the alleged employee's investment in equipment or materials required for your work, for the task that's involved, and whether what you're doing requires a special skill that somehow makes you distinctive than the average population. The degree of permanence of the working relationship. If you have an ongoing relationship that has lasted years with a language services provider, that may indicate that you are an employee and not an independent contractor. Again, there are a lot of factors that come into play, but just think about how you work with your clients, how you work with companies that pay you. Have you been working with the same company for 10, 15, 20 years? Well, that may mean they have some level of direction over what you do. It may. Again, it's not necessarily so. But think about how much you are directed to perform your job, to provide services in a certain specified way. The more you are told to do that, the more you are directed to do that, it makes it likelier that you are an employee. So the 6-factor test, as we just talked about, notes that the right to control. And I know, as I said, I'm going to be hammering this throughout the webinar because it's really important. The degree to which an employer controls a worker is, quote, highly relevant to the Fair Labor Standards Act analysis, unquote. The worker's, quote, degree of independent business or organization and operation is also important. It's not as important as the right to control, but it is certainly a factor. So that also indicates, for example, if you are an independent contractor, do you have a business license from your county and state? Have you formed an LLC or a limited liability company or some other legal entity? Again, whether you've done that or not doesn't mean automatically, oh, Bruce has an LLC, so he's an independent contractor. No, it doesn't work that way, but it can be a factor in evaluating whether you're an employee or a contractor. Also, frankly, it could give you some legal protections from liability that really go beyond the scope of today's webinar. If it's not something that you have or have done, I strongly recommend that that's something you look into, because it is very wise to have some liability protection against you personally. Very, very important, very wise to do that. Okay, so this is an interesting excerpt from an article in the Times Union of San Diego 2 years ago. This was after AB5 passed. So citing the 3-factor test that California used, so it's called the ABC test. So under the ABC test in the original AB5, a worker can be an independent contractor only if he or she, A, is free from control and direction, B, performs work that is outside the usual course of the hiring entity's business. And C, is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So as the Times Union said, is there any freelancer out there or independent contractor who could possibly pass Part B, that you're doing work for an organization that's outside of what they usually do? So if, let's say you are working with a state court and you are providing translations of various materials for the court. Now, as you know, and as Rosanna had said at the beginning, Title VI of the Civil Rights Act of 1964 requires courts to translate certain information for limited English proficient people. So they already have to do that. So, rhetorically, how is what you do different from what they're supposed to do in the usual course of business? So that shows you this ABC test in the original AB5 was pretty narrow. And there wasn't a lot of wiggle room in who is and who is not independent based on exactly how you do the work that you do. But I think that this is also important in the aspect of advocacy, and as Rosanna suggested at the beginning, of letting people know about what we're talking about today and the this issue, because it really impacts everybody, how you work and how you do your job. So AB5 was written with companies like Uber in mind. The translation and interpreting industry spoke out in regards to how it will affect them and how it will affect their constituents. But despite this opposition, the bill passed anyway, without any sort of exemption for translators and interpreters. Both the ATA and the International Association of Conference Interpreters opposed the law, highlighting the importance of an exemption, but they didn't get one. And without talking about why, the who's and whys, why they didn't get one, I think it is really important to have an understanding of issues that affect your profession, affect your job, affect your ability to perform your profession the way you want to. And that often means having effective advocacy and effective lobbyists who can advocate for you and protect your interests. That wasn't done initially with AB5. So excuse me, I think this is true. The original AB5 essentially banned how many translation companies would conduct their business in California. The ATA pointed out that few language services providers have sufficient work to hire individual translators and interpreters as employees for every language on the market. Well put. And there are all kinds of languages of lesser diffusion that organizations don't necessarily see them on a regular basis. So if you are employed as an interpreter or a translator for languages that just don't come up that often, yeah, that raises the point of why would I want to hire you as an employee to do that work, which comes up, maybe once a week without any sustained regularity. I thought this was a really interesting point. Lorena Ortiz Schneider, a professional interpreter and translator for almost 30 years, quoted after AB5 was passed, says her industry was overlooked when discussions about exemptions were occurring. Most people don't know we exist, she said, referring to fellow translators and interpreters who work in administrative hearings, courts, classrooms, medical centers, mostly on a per job, per contract basis. They did not get an exemption to AB5, meaning the way they work and whether they'll be able to work is now in question. So you saw some of the industries like doctors and lawyers, veterinarians, who did get an exemption. And I think this points out the vital importance of effective advocacy and knowledge of issues that affect you and how you do your job, which really points to one of the themes of today about what's happening in Washington, which we'll talk about later on. So as Ms. Schneider said, we mobilized too late. We started in mid-June. Remember, this bill was passed in September. So starting the conversation 3 months before the bill is set to be voted on is probably not too timely. There should have been a much longer lead time and much more focus earlier in educating legislators about what translators and interpreters do, how they do their jobs. Remember that chart I showed you at the beginning, that 75% of you work as independents. You work from home, you work for yourself, and you're not in-house on staff as an employee of a healthcare provider or a language services provider. And as she says further, we're not a well-organized lobbying group historically. She says that while AB5's goal of protecting workers is worthy, it doesn't take into account how interpreters and translators work. And I think based on the laws that originally passed, I think that's true. And I think that the legislators, by and large, didn't seem to realize the information I just restated about 75% of you are independent and you work for various clients or organizations. I don't think they understood that. There was a 2010 Common Sense Advisory market research study that concluded again that the vast majority of interpreters in North America are independent contractors, and that, quote, being nailed down to a job, unquote, would make meaningful communication and language access virtually impossible, as I mentioned earlier, because depending on the languages that you specialize in, that you're proficient in, that you're fluent in, if they don't come up every day, if they don't come up regularly, why an employer is going to be thinking, well, why would I hire Bruce as an employee when he's only going to be doing the language services part of his work intermittently or irregularly? Now, so let's get into what's happening in Washington. So the U.S. Department of Labor earlier this year published a notice proposing to withdraw a new rule that was issued in the last 2 weeks of the prior administration. This was before President Biden was inaugurated, and the rule would have allowed employers to more easily classify workers as independent contractors under federal law. The rule was called Independent Contractor Status under the Fair Labor Standards Act. And at the time this was issued in early January, it was considered a major win for employers, and specifically for companies involved in the gig economy. So this would have meant a significant saving for them as far as all the things we talked about earlier: minimum wage, unemployment compensation, workers' compensation, all kinds of things, big saving for them. So this was one of the priority items with the Biden administration when they came into office. It was clear that they were going to withdraw this rule, this regulation, and that's exactly what they did I think it might have been in March. So in the Labor Department, and please look carefully at that second paragraph, in its withdrawal, the notice to withdraw this rule, the Labor Department stated that the rule's narrowing would result in more workers being classified as independent contractors, not entitled to these FLSA protections that we've talked about. The rule may also have had a disproportionate impact on low-wage and vulnerable workers, given that women and people of color are overrepresented in low-wage independent contractor positions. And I think that, plus this next paragraph, are really key. The department cited a report which found that 42% of gig economy or platform workers and 45% of self-employed sole proprietors make less than $20,000 a year. I think part of the Biden administration's push on this is because they view this as a worker equity, social equity issue, that they feel that there has been discrimination against women, and primarily women and people of color, and who are overrepresented in the number of people who are independent contractors. I think that's part of what is driving this. It's not all that is, but I think that's a big part of it. And I think that kind of informs where things may be going if the administration, which they are, if they consider this the priority that they do. So right now, since the rule under the last administration is gone, that was withdrawn by the Labor Department, that the only guidance that's out there about misclassification with the Labor Department is what's called Fact Sheet 13. So if you go to the Labor Department website and put into the search engine Fact Sheet 13, you'll see what that talks about. But that also goes into the key factors in determining who's an independent and who's an employee, along the lines of what I have talked about, and also as I'm going to talk about it more as we proceed. So right now, there isn't any current guidance, current rule, current regulation from the new Labor Department about this misclassification issue. What does that mean? Well, in large part for now, that means relying on this Fact Sheet 13. What it also means is it's coming. There will be a new rule or regulation that defines this employment relationship. And as I said, my expectation is that it will be more favorable to classifying workers as employees rather than contractors. Okay, so as you know from earlier, employers who misclassify employees may be liable for significant money damages under both federal and state law, and they should review the law in whatever state they're in to ensure that they're classifying people properly. Each state, the laws vary. The state law about misclassification, they vary state by state largely. And some of them track what federal law says and use the test that we've talked about, and I'll explain other tests as we go forward. But they all incorporate that right to control, right to direction indicator as well. You're a contractor or an employee. Okay, so I'm going to pause after I introduce this. It's really important, I think, to become familiar with these tests here. So this is an excerpt from that Fact Sheet 13 that I just mentioned. The U.S. Supreme Court for decades has, in many cases, indicated there's no single rule or test for determining who's an employee and who's a contractor. The court has held that it is the total activity. Remember, we talked about this is a very heavily fact-based determination. So it's based on all these factors, the total activity or the situation, which governs how the worker works. So these bulleted points are the factors that the Supreme Court has consistently mentioned as significant. So I'm going to pause so you can read them, take a picture of it. And I know, as Rosanna said, the PowerPoint will be posted, but just to give you more of a sense of, well, trying to determine what your classification is, how you classify it, this is a good place to start until the Labor Department does what it's going to do. So I'll pause for a bit so you can read this. As you can see, all these tests basically go to this issue of control and direction. And look at the ones at the bottom, the degree to which a worker has an independent organization or operation. And that often is, was that person based? Does that person have an office? Does that person report to work every day at 9 o'clock at a hospital, a court, or a language services provider? The one above that, the amount of initiative, judgment, or foresight in open market competition with others, is that required for the success of the contractor? So how often is there competition? You know, as an attorney, when I bid for opportunities, I'm competing with other attorneys. And they're, you know, whether that's for an hourly fee, total cost, or description of the services we provide. So that's certainly true with what I do. And look at, to the extent that you feel that that's operative for you. how much initiative, judgment, or foresight is used in open market competition and getting the jobs that you get with other language services professionals. And the alleged contractor's opportunities for profit and loss are not for an individual job, it's for your business. So if you don't get a certain contract, how does that factor into your being able to make money, whether you have a net profit or a net loss? So that's what essentially that means. And you know my favorite one, the nature and degree of control by the organization for which you're working. The amount of how much money you've invested in your home office, in a computer, a printer, Wi-Fi setup, all kinds of things that would be relevant to the work that you do. And again, if you have a long-term relationship with a particular organization, to what degree is that essentially permanent? That you have an expectation, and they have an expectation that you will continue to work together indefinitely. That certainly plays into who's independent and who's an employee. So the Labor Department suggests that that rule that I mentioned from the last administration they got rid of may also have had, again, a disproportionate impact on low-wage and vulnerable workers, given that women and people of color are overrepresented in low-wage contractor positions. I'm repeating this here just like right of control, because I think this is really important to get a sense of why the Biden administration views this as such a priority. And there's no question that they do. As I said, part of it is this issue of equity, this issue of disparity, to alleviate that, to address it by having a more level playing field so that everyone is classified, or most people are classified as employees. I think this is very true. The whole idea of who's independent and who's an employee has really become now to seemingly depend on what party controls the White House. Democrats and Republicans have a different view on this classification issue. So I think this is very true. Which party controls the White House often will have a clear relationship to how that administration views classification. Who's a contractor, who's an employee? I think that's a really interesting point. And really you should think about it together with the right of control and that the multi-part test that I mentioned that the Supreme Court has put out. Courts may view any Labor Department test in this context with skepticism and thus cause them to fall back on the same kind of standards that they've used for 80 years in the absence of a clear Labor Department definition of an employee. I put this here as a point of thought and discussion. I don't think that I necessarily agree that courts uniformly will view a new Labor Department rule skeptically. I think that there may be some courts that do, but that's true with almost anything. I don't think that by and large courts are going to look at a Biden administration Labor Department rule skeptically and say, we're going to toss this out because it's arbitrary and capricious and it's based on partisan politics. I don't see that because the law basically gives a lot of discretion to federal agencies in their rulemaking procedures. There's a presumption of deferring to the expertise of an agency. So I don't think courts on the whole are just going to throw out a new Labor Department rule on the classification issue because there's a Democrat in the White House. I don't see that. But, I know that there are folks who do think of it that way, but I thought a lot about this. I don't see that happening. So the ABC test is, one of the traditional tests. And as we talked about with California, that was something that was at the core of AB 5 and a California Supreme Court decision on which AB 5 was based. So you can see here again the factors. The individual is free from control and direction in connection with performing their services, both under the contract and in fact. So that means that under the contract that there's nothing in the contract that says I, as the organization that pays you, require you to do 1, 2, 3, 4, 5, 6, 7 things, and you have to do them in the way that I spell out in this contract. So that's what the contract for the performance of services refers to. And in fact, again, this is a fact-based determination. Remember, that's what the courts have said. So in fact means how exactly do you do your job? Does the organization call you up or email you once a week or text you and say, okay, today, Wednesday, 9 to 12 is weekly required training that we provide that you must take? Well, that indicates some level of direction and control, and could be, again, another example that this organization has other methods or means or requirements for controlling how you do your job and when and where than just this training example. And the last one, the C, the individual is customarily engaged in an independently established trade, a profession, or business. So as you saw at the beginning, that survey, I think you may have a good argument that the language services industry, by definition, is independently established because 3/4 of translators, interpreters work independently. That's an interesting argument to make, and I could see that that may apply to C. So this ABC test imposes a higher burden on businesses classifying workers as independents than the economic realities test. So, without going into a lot of detail about various tests, the economic realities test in part is that, remember that slide with the bullet points about the Supreme Court, what they've said over 80 years, that's about economic realities. And I think, again, as we've talked about, just remember right of control or direction. If you think that you are being controlled or directed by the organization for which you work, it's likelier than not you're an employee. So under the ABC test, the vast majority of workers will likely be considered employees rather than independent contractors. It was proposed as a governing test under the National Labor Relations Act, which is part of the PRO Act, which passed earlier this year by the U.S. House of Representatives. I want to address this briefly. There's been a lot of talk about the PRO Act becoming law, and it's being considered in the Senate. And yes, it is currently in the Senate. It is being considered. There's no way the PRO Act is becoming law, period. You can quote me. I don't see any possibility that the PRO Act as written will be passed by the current U.S. Senate. So if I'm correct, that means the PRO Act is dead. It's not going to become law. And I think, assuming that it is, I think is dangerous because it may betray a kind of not fully accurate view of how Congress works. And as I said, there's, from everything I've seen and what I've been told and what I know about Capitol Hill, I see no possibility that a 50-50 Senate is going to pass the PRO Act, period. So just speaking very rhetorically, I see the only possibility of that is for the Democrats to have at least a 60 vote majority in the Senate so they can avoid a filibuster. But that also suggests that every Democrat elected in the Senate is likely to vote in favor of the PRO Act. I don't think that's going to happen either. So to me, the PRO Act isn't going anywhere. And I think that kind of informs some next steps, which I'm sure we're going to talk a little bit about the Q&A, and I'm going to address a little bit more as I go on. So this is important to remember. Merely labeling someone an independent or having them sign a contract that says you're an independent contractor does not necessarily make them so. Remember, this is a fact-based determination. Totality of the circumstances and how you work with, deal with the organization that pays you. Whether or not they label you as a contractor, an employer, or someone from a different solar system, doesn't matter. It's how you actually do your work, how you're directed if you are, how you perform the services, how, when, and where. That matters, not whether you're labeled a certain way. Excuse me. It's not always clear, of course, whether a worker is an employee or independent. There's no set number of factors that qualifies a worker a certain way, and this determination must be made or is made on a case-by-case basis. But if the right of control, right of direction is clear that that's what's happening, that will be a strong indication that the worker is an employee. So I think the next couple of slides just give you more of an idea of factors that come into play to make the determination that a worker is an employee. So I'm going to pause so you can read this. And again, I think all of these things relate to direction and control. How are you paid? Are you paid weekly, hourly, monthly? Are you paid on a flat fee basis? Are you paid on a negotiated hourly fee? All of that is going to factor into this. Are you an employee or not? Do you use your own equipment? Or if you're using equipment the employer requires, that's also a big indicator that the employer has this right to direction and control, or is utilizing direction and control. You receive predetermined earnings and cannot realize significant profits or loss overall in your business. So that significant predetermined earnings, like getting a paycheck, flat fee every 2 weeks, for example, on an ongoing basis, that strongly suggests, again, that the worker may be an employee. Schedule dictated by the employer, really important. If the employer says, I want you here 9 to 5 every day, that's a pretty good indication of direction and control. That's different than the organization saying, I have a job for you at 10. That's not the same thing as saying, I want you on the job ready to go at 9 o'clock. Not the same thing. If your employer, if the organization trains you or requires you to be trained by them, that's different from an organization like laying out some training options and saying that their client requires training, or that interpreter associations require, recommend training. That's not the same thing as that organization saying, you must do this and you must do it in my house. That's them saying that their clients for which you work require you to do that. So that's entirely different than the employer saying, Bruce, you got to do this training, and do it in our place of business. You receive benefits, insurance, pension, paid vacation, or sick leave. Yeah, those are pretty good determinants of being an employee. The relationship between employer and worker is ongoing. Again, it's not a job or project basis, that you've been paid for years a set sum of money to be available for an organization, that without doing anything, that you're just available for them to work and they pay you $2,000-3,000 a month every month. Yeah, that could be an indicator too that you're an employee. So here are factors indicating whether you're an independent contractor. And I'll pause so you can read this. All right, so again, whether your contract says you're an independent contractor really is not going to decide the issue. Are you free to determine how you do your work? Paid for each job. If you're paid per job, then that's a better indication that you're independent than if you're paid a flat fee each month to be available for work. You use your own equipment. It is important that you have bought, you haven't been reimbursed for, not equipment that organizations are giving you, loaning you, renting to you. Can personally realize significant profits or loss in your business. You control your business, you control your work, you control what work you do, you set your own prices. So you determine whether you have a net profit or loss. You work temporarily or on individual jobs. So let's say you work 2 or 3 times a month or 2 or 3 times a week. But you decide what your schedule is. Well, I don't really want to take that job. I'm not available on Monday. I'll see if I'm available on Wednesday. So again, you're setting your schedule, you're determining how you work and when, and that is not the same as the organization directing you. Bruce, you must be available every Monday, and you have to be available 9 to 5. That's, again, direction or control. And interesting, I think this is, I like this. This also really teases out some good rhetorical questions. So facts that provide evidence of this degree of control typically fall into 3 categories. 1, behavioral. Does the company control or have the right to control what you do and how you do your job? Financial. Are the business aspects of your job controlled by the payer? These include things like how you're paid, whether expenses are reimbursed, who provides you with supplies and tools to do your job. 3rd, type of relationship. Are there written contracts or employee type benefits, like a 401k plan, vacation pay, for example? Will the relationship continue, and is the work performed a key aspect of the business? So is this something that's ongoing business that relates to what the organization that pays you, if that's part of the regular course of their business, that may, again, indicate that you're likely to be an employee. So again, as we end, but I want to talk about something after this slide. Please remember, there's no magic or set number of factors that makes you an employee or an independent contractor. And no one factor is like overwhelmingly number one, in the sense that if that happens, that's it, that decides the issue. That being said, I would go a little further than the IRS in saying that if the right to direction, if there's direction and control by the organization for which you work, to me, that's likelier than not that you're an employee and not a contractor. The keys are, and I agree, to look at the entire relationship, the whole situation, all of the circumstances and the facts involved in your relationship, and considering the degree or extent of this right to direct control. And finally, documenting each of the factors used and coming up with this determination. That's certainly what a federal agency does or a court does. All those factors we've talked about, ABC test, the factors I mentioned a couple of slides ago about factors to suggest that someone's likely to be an employee or an independent contractor. But the keys clearly are what I've been stressing: the right of direction and control, where you work, how you do your job, how you're paid. Those are among the more important ones. And just to, I think this, I do have a couple other slides. Lowe's had a settlement of $6.5 million in 2014, plus an additional 25% attorney's fees to settle a class action suit brought by installation contractors, claiming they were misclassified as independents instead of employees. Why? Well, look at this. Lowe's classified them as independent contractors, but they gave them Lowe's uniforms with a nice Lowe's logo. They required them to attend Lowe's training sessions and to identify themselves as installers for Lowe's. So all of those are pretty good indications that, hey, you know what? I don't think these people are independent contractors. I know you want them to be, but I don't think they are. So these actions and others clearly, as you see, blurred the line between employee and contractor. As employees, they would have been entitled to the benefits you see, medical insurance, and be able to contribute to a 401k plan. So if you're being given that opportunity, you're likely an employee and not a contractor. As you can see, this misclassification just brings you under the thumb of federal agencies or even a state agency, and will likely involve some government audits, and you're having to sign, an organization having to sign some consent decree or consent document. Under federal law, again, overtime liability is generally double damages plus attorney's fees going back multiple years. that a state can increase these amounts. You can see in my home state of Maryland, overtime liability can be triple damages plus attorney's fees. So we're talking big money. Why? What do you do? Well, what do you do is part of what Rosanna said at the beginning, being informed about this as an issue, understanding the ramifications, understanding the distinction between independent contractor and employee. And I also want to point out before we go into Q&A, remember the PRO Act, Congress isn't doing anything about that as it's currently written. The action is going to be at the Department of Labor. So this is not a situation with advocacy of having a Hill visit or what are called Hill days, where Congress is visited by many people of different professions, part of a trade association or a trade group, for example. This will involve lobbying, advocating with the Labor Department. Doing advocacy with a federal agency is not the same as going up to Capitol Hill for a Hill Day and having a 5-minute FaceTime with your U.S. congressman, senator, or members of their staff. So what you do, of course, is up to you, is how you view this as an issue, how you feel that this may affect you. But one of the things is this is coming. This isn't a question that the Biden administration will say, we changed our mind, we don't care about this. That's not going to happen. To me, it's a matter of when this happens, not whether it happens. So I think this is clearly a priority for labor. That's not going to change. And if this is something that you feel is important, then it's a matter of, all right, what do you do? How do you get involved? I think that's going to be something that's going to be coming up with NCIHC. We could talk a little bit about that in the Q&A, but please keep this in mind. So you're not in a situation like Ms. Schneider said about the passage of AB 5 in California in 2019, her comment that we were overlooked and ignored. If this is important to you and you feel important to your profession, don't be ignored. Get involved early and advocate effectively. That's my contact information. So my presentation is done, and I look forward to your questions. So thank you very much for your time today, and I'll turn it over to Rosanna.
Thank you so much, Bruce, for this really, really useful information. I'm sure everybody appreciated it. We have quite a bit of an engagement happening both in the chat area and obviously in the Q&A box. So I'm going to try to go to some of these questions, and without a promise that I will be able to cover all of the questions given the time constraints. But I guess one question that pops really, that screams at me right now is, how do we advocate with the Labor Department?
Well, Rosanna, one of the things I like about you is you always go right for the core. You don't waste any time. Well, one of the ways that you do this is, first, go to the Labor Department website and familiarize yourselves with what labor has said in press releases, for example, about misclassification. Look at what the notice was that labor issued, I think it was in March, to revoke that old rule under the prior administration. Start by familiarizing yourself with the issue and familiarize yourself with what labor has done to date. That's a good place to start. When I worked for the Justice Department, people that lobbied us most effectively were the people who really knew their stuff. They came well prepared with an understanding of what justice may be doing and a clear agenda of what do we want to see happen now. So that would be my first suggestion. And becoming familiar with what labor is doing may inform how you approach the Labor Department as an advocate. This may be a situation too, where if someone has a great relationship with a U.S. congressman, a U.S. representative, or senator, ask them about their contacts with the Labor Department. Maybe they have a name. that could be somebody you talk to. That's a good place to start. Because not surprisingly, the Labor Department or all federal agencies are massive, and figuring out where to go can be hard. This is not something I suggest you try to make an appointment with the labor secretary. Now, if you have a contact or relationship, potentially, but if you don't, just trying to do that blind, that's probably going to be a bit of a stretch. So first step, go to the website, learn what labor has done, become familiar with the notice that they put out in March, and then look to see what contacts you may have. Start with your federal representative and see if you can get a name of someone to contact. If not, a lot of federal agency websites list various officials in various offices. Look to see if there's an official concerning the Fair Labor Standards Act, for example. There may be a name and an email. Maybe that's a good place to start with a contact.
Okay, thank you. Fantastic. I'm going to switch gears here with a different type of questions. With interpreters through agency, there are two layers of employer, the agency and the healthcare organization that pays the bills. So who would be the employer?
Well, that's a great point. If you're working with a language services provider, they're paying you. Now, part of the pay comes from what their client pays them. So you are working directly for them, not for a hospital, for example. So like many interpreters who work independently, they're given jobs by language services providers, but in a way, you could look at them as like the middle entity between you and the hospital, you and the police department, you and whoever wants language services. But you're working with that language services company most likely. Remember, I talked earlier about a language services company telling you that you must do this and this, but they're not telling you that. They're passing through the requirements of the hospital, for example. So if a language services company says, you have to do this training, for example, and it's training that our client requires, we're not requiring you to do this. We're telling you that if you want to do work with this hospital, they require that you do this. It's the same thing with COVID-19 vaccinations. The language services company may pass on what their clients require. So you're working for the language services company. If they are telling you what their client wants you to do, that's not the same as they're saying, we require you to do this. For you to be listed or be part of our group of go-to language services professionals, you have to do this. No, if it's something that they're telling you their clients require, that's different.
Great, thank you for clarifying that. And I do see that participants are raising hands. Please, rather than raising your hand, go ahead and use the Q&A box to ask your question. Okay, going to another practical question here. If an interpreter has a long-term assignment, could that be construed as an employee classification?
Well, you may love or hate the answer, but the answer is it depends. So it really depends how long. We're talking about a 10-year contract or a 6-month contract. 6-month contract has a clear end date. That's not the same as my having a contract with you each year that says Bruce will be available for us to work whenever we want him to work, and paying me a set amount of money so that I prioritize working with this company. That is that degree of permanence long-term that all these tests talk about. So a 6-month project doesn't mean by itself, for example, that you're an employee. It would be a much longer relationship. And think about how you're being paid. If I pay you to be available to me each month to work, I give you a flat amount of money, that suggests a permanence to our relationship because I'm not paying you per job. I'm paying you to be available to me to work. Well, isn't that like an employee? When you're an employee, you have to report to work a certain amount of time at a certain hour. You work an 8-hour day and you get a paycheck every 2 weeks. So that's kind of similar to my paying you 2, 3, 4,000, whatever it is, per month to be available for me to assign things to you on an as needed basis. So don't think just because you have a long-term project that by itself means you're an employee. Remember, it depends. It depends on all the facts that are involved. Think about during this 6-month period, how much do they control what you do? How much do they direct you? That also has, as you know, a very key relevance to whether you're an independent or an employee.
Thank you for clarifying that, Bruce. Here is another question that comes from one of our attendees. Is a lawsuit the only way in which employers have to face payment of damages for not classifying an employee correctly?
Yeah, that's a great question. I mean, that is one way. Another way is if the employer is investigated by, let's say, the Federal Labor Department. There have been a lot of 6 or 7-figure settlements of misclassifications. These settlements were initiated by state departments of labor. So this has been a kind of hot thing for the last few years. There have been a lot of settlements in many states about this misclassification issue. So lawsuit, yes, but also these investigations by a federal or state agency, those will come with penalties.
All right. So thank you so much. And here is another rather long mix of comments / question that we want to honor. Bruce, could you briefly explain the definition of subcontractor? This question comes because our industry seems to be all over the place, and the nature of our work leads us to work under very different denominations, depending on how we get hired.
Yeah, that's a great question. Subcontractor would be like this. Let's say I have a contract to provide interpreter services for a state government agency, and I need additional interpreters other than me, for example, to do the work. So I would then contract with interpreters who would work for me as what's called a subcontractor. I have the contract with the state agency. Subcontractors, interpreters would be working for me. I'm the contractor. I'm the one who signs a contract with the state agency. The interpreter signs a contract with my company so that you're working for me, with me. And that's kind of what I was mentioning earlier with language services providers. Sometimes you can view them as a pass-through between interpreter and hospital, let's say. But a subcontractor works for a contractor. Subcontractor has no direct contractual relationship with the state agency in my example. So your recourse, meaning if there's a problem, if there's some issue, you have recourse. You can challenge, you can sue, you can file a complaint with the language services company, my company that hires you. You have no contractual relationship with the state agency. I'm the only one who does. So there's really nothing you can do to sue the state agency. You can only come at me through a complaint or a lawsuit because I'm the only one with which you have what's called privity of contract. That means you have a contract with me. You have no legal relationship with the state agency in my example.
Great. Okay, here is a very hands-on question. How do you suggest that we approach or address this with prospect employers when they say, And just one moment, because my screen just jumped here. Okay, when they say we are an independent contractor, but we feel we're being treated as an employee, and what recourse exists when there is a disagreement on the classification that we have?
Well, I think the first step is, like I said at the beginning, think about how you work with the organizations that pay you. And think about all the tests we talked about and the issue of control and direction. How much are you controlled and directed by the organization that pays you? Those are really important. And like in my example, are you paid a flat fee every month to be available to work? If you are, that suggests to me that you may be an employee, rather than an independent. So keep in mind, this is a case-by-case thing, and you have to look at lots of factors to figure out, okay, which one am I? But the one that always is number one is the direction and control. You evaluate on your own first whether you think that's happening, how you're being paid, how the work is done, what are you told to do and not do. So that's important to look at. I think that if you feel that you are misclassified, the first thing to do is, are there other people like you who are also misclassified? Then I think you might want to consider talking to an attorney. Or if you don't want to do that, then you may want to file a complaint first contact the organization and tell them you believe you're an employee and not an independent contractor. Now that has its own risk and its own consequences. They may not like that you're doing that. They may say you're not working for me again. But keep in mind too, that if you are being misclassified, you have the right to all these things under the Fair Labor Standards Act and similar state laws. So it's like in many situations, just like I said in my last slide, well, what do you do? Well, first it comes down to how far do you want to go? What are you willing to do? But the first steps of what I said is look at objectively your situation with the organization. How do you work with them? What do they tell you to do or not do? Are there other people who are in the same situation as you are? Consider going to see an attorney. Consider having several people involved in a claim, because that also can be powerful. And then deciding after you speak to the attorney, what does she tell you and where do you want to go from there? But you do have a lot of options, and this misclassification thing is big stuff now. The agencies, federal and state, are very active. And I would say it's likelier than not that if the facts support a misclassification claim, the agencies are much likelier to do something now than they would have been several years ago, because this is such a hot topic these days.
So this Q&A box is on fire, Bruce, and I'm going to try to combine a couple of them that are sort of aligned, and keeping, of course, my eyes also on the time, on the clock. So, you mentioned about control and the extent of control by an employer or the partner. But what if the agency requires that interpreters purchase liability insurance, or if they want to have some control in how interpreters observe infection control measures? How does that affect the classification?
Well, that's a good point. And I think the best part of that question is thinking through all the things that we talked about and starting to evaluate, well, wait a minute, they tell me to do this, this, and this. Is that control? Why do they tell me to do that? Well, let's look at the specifics. Requiring liability insurance, I don't view that by itself as indicating direction or control. It may be part of a larger picture that indicates control, but just by itself, I don't see that as being dispositive, as being determinative of classification. And the about infections and vaccinations. You know, as I said, if you work in healthcare, the odds are the hospital that you may be assigned to, you may do some work on a per job basis. They have a requirement for regarding vaccines, infections, not working when you're sick. So, excuse me, if the language services company tells you that, that's likely just coming from their client. I don't view that by itself, again, as being determinative. Even if you combine that with the liability insurance, I don't think that that's enough, because all of these things are likely to be coming from the language, the LSP's client. So it's more the client's requirement, the client of the LSP, than the LSP telling you to do, all these 10 things. So by themselves, I don't think that they make out a misclassification claim. They may be part of a larger picture, but that's going to depend on what the other factors are and how much, like, for example, is training required by the LSP? Do they pay you vacation time, for example? So there would have to be other indications of direction and control for those two issues for those two issues in combination with others to prove misclassification.
Great, fantastic. And this concludes our Q&A session. And we have a few announcements before we end today. As you leave the webinar, you will be directed to an evaluation form to provide your feedback on today's webinar. You're also welcome to share your comments by emailing us at info@ncihc.org. The NCIHC is a multidisciplinary organization whose mission is to promote and enhance language access in healthcare in the United States. If you're not already a member, we encourage you to become an NCIHC member and take advantage of the many benefits that NCIHC has to offer. If you are already a member, thank you. We encourage all members to learn about additional ways to get involved through the various committees and other work groups. My colleagues are going to be copying a couple of links in the chat area. These are links that you can use to learn more about members' benefits and the organizational structure and how to stay involved through our committees as well. So Bruce, would you mind advancing one more slide?
Oh, sure. Oh.
Thank you again. On behalf of the National Council on Interpreting Healthcare, we thank you, Bruce Adelson, for this timely and eye-opening presentation. Thank you to all our attendees. I want to also thank our tech backup people, our gurus in the background that you didn't see, Amy Niven and Linda Golly. We look forward to offering more presentations on matters of importance like this and to other matters in our profession. Take good care, everyone. Have a wonderful rest of the day and great weekend. Bye-bye.
Thank you. Bye-bye.